Welcome to Idea to IPO. Hello, my name is Jennifer. Idea to IPO has been holding tech startup events in Silicon Valley for many, many years. We organize venture capital panels, legal workshops, and more. Please check out our schedule at ideatoipo.com. Our featured speaker today is Roger Royse, and he is one of the top venture capital attorneys in Silicon Valley. And he is also passionate about helping entrepreneurs succeed. Ladies and gentlemen, Roger Royse. Roger, please take it away.
Okay, give me a minute to let the thunderous applause die down. And thank you very much, Jennifer, for that introduction. I'm Roger Royse. I'm a partner with Haynes Boone in Palo Alto. I work in emerging growth and venture capital. I'm a corporate and tax lawyer. I work primarily with startup companies, sometimes the venture funds that invest in them, do formations, financings, commercial contracts, and M&A. Okay, so today's panel, it's not a panel. Today's presentation is top 10 legal mistakes that could kill your startup. So if that's what you're here for, you're in the right place. So before we get going, a couple housekeeping items. Those of you who have been here before, you know how this goes. I'm going to talk for about an hour till the top of the hour, 1 o'clock Pacific, and then we're going to go to a Q&A session. So as we go along, you're going to have questions. Post them in the Q&A dialog box, not in the chat. That's for something else I'm going to tell you about in a minute. Post the questions in the Q&A box. I'll get to them at the end. The second thing to keep in mind is that this is being recorded. And if you've signed up here today, you are going to get a copy of the recording. You'll get a copy of my slides. And you picked a good day to tune in. You picked a good day to tune into Idea to IPO because you are going to be the very first people in the world to get an advanced copy of my new book, 10,000 Startups, Legal Strategies for Success. That hasn't even come back from the printer yet, but I do have a soft copy that I'll be distributing. And you're the first because it's, I just got the copy last weekend. All righty. Couple of other things. Thank you to Idea to IPO for hosting and handling everything here. I am just your speaker. Idea to IPO is responsible for everything except the content. Now, what else? What else should I tell you? I think while I've got a couple other announcements, but while I'm doing that, I think I'm going to start. Did I enable polls? Yes, I did. I'm going to take a little poll here. I'd like to know who's in the audience. Are you, okay, go. Let me know who's in the audience. I always like to know who's here. Are you an entrepreneur? Are you an investor? Are you a service provider like me? Go ahead and, so far it's almost all entrepreneurs. Let's see, we have a couple of investors. We have some students or professors, but 80% startup entrepreneurs so far. That's a lot. Okay, let me end that poll with 80% startup entrepreneurs, and then a kind of a smattering of everything else: investors, service providers, academia. Let's do another poll. Where are you from? Because that will inform a lot of what I say. And while I'm doing that, I'm going to post in the chat my information so you can find me. At the bottom is the YouTube video. I'm going to post this presentation on YouTube. Then I post all of these. Make sure you view that. Click on that YouTube and please subscribe. I need more subscribers. And also find me on LinkedIn and join our group, our LinkedIn group, Startup Solutions. I think you'll like it. Okay, 25% Silicon Valley, 50% other North America, 6% Asia, 8% Western Europe, 2% Eastern Europe, Latin America's got 4%. South Pacific's got 2%. Wow, we're all over the place today. But it's still 75% North America if we include Silicon Valley. Okay, that's good to know. Okay, let's close that poll. All right, so we have a pretty diverse audience, although most of it is right here. Okay, that's it with the announcements. That's it with the polls. We're about to head into the content. If you're tweeting today, tweet hashtag ID at IPO. Make sure you find me on all my social media steps. And now comes, hold on here. Now I'm going to, hold on here. I'm going to share my screen. So you're going to have to give me a minute because this is a little bit tricky. Now, what I'd like you to do is I'm going to share my screen, which you should see in my screen as a title slides, my opening title slides. It's top 10 legal mistakes. Somebody send me a chat. All right, you can see it. Awesome, awesome. That's great. Good to know. Okay, well, let's jump right into it. First of all, I don't have my disclaimer slide up, so I'll just tell you, this is just general advice. This is not specific legal advice. If you need specific legal advice for your particular circumstances, you'll have to talk to me or another lawyer personally. I'm just giving you some general guidelines here. So let's jump into it. Top 10 legal mistakes. And let's start with my number 10 one, which is using a prior employer's facilities. So here is the scenario. You're starting a company, maybe you and your friends, and you've got an idea, and sometimes called a side hustle. And people do this on nights and weekends here in Silicon Valley. They don't quit their day job until they get a little further into it. That's usually how it happens. So the very, very first question I'm going to ask somebody when they come into my office and sit down in my conference room and meet with me like they used to do 2 years ago, or find me on a Zoom call like we do now, the very first question I'm going to ask, I'm going to say, well, now, are you sure this is your idea and it doesn't belong to anybody else? So do you have a day job? If yes, I have a day job, then we got to go through, here in California anyway, we have to go through these criteria to make sure that the prior employer is not going to come along and claim rights to the business that you're creating. So number one, it's got to be created on the employee's time, not during working hours, but nights, weekends, whenever they're not being paid for their current employer. Secondly, you can't use any of the current employer's facilities. Their phones, their computers, their offices, their labs, etc. You need to do this someplace else on your own computer. And by the way, you need to assume complete transparency because your employer probably has it. You might not know it, but they probably do. The thing that you're doing should not be related to the employer's business. And finally, it should not result from work performed for the employer. In other words, it's not the thing they hired you to do. It's that third prong that's really the most difficult, because that's the one where we say, well, is this so close to what my employer is doing that they're going to claim that it's theirs because I was working for them and they have a shop right, I have a fiduciary obligation and all of this stuff. So that's the toughest one. So that's the one to be careful about. Now, those are the rules. When we go through it, of course, it's a highly factual analysis. Now, let me tell you how this plays out in practice and give you some practical takeaways from this. Because like I say, most companies I see, and I see tons of them, they start off on somebody's spare time. And usually, if we know the rules, we can navigate this pretty carefully. If we are a little close on that third prong, well, then stealth is going to be important, right? And one of the mistakes everybody makes is they go and they announce on their social media a little too early. And I can promise you every employer is looking at your LinkedIn account to see what you're up to. And I've had it happen in these cases where, because you can kind of see who's pinging your account, that all of a sudden somebody gets a lot of, somebody's checking out their posts on LinkedIn Well, that's probably because you just updated it and you added your side hustle. So just be super careful about social media and this stuff. It makes a very bad record if you're trying to make a good record. And sometimes, like I say, it's not absolutely clear cut as to when you quit one thing and started another thing. So sometimes we have to dress the baby, and you might have a really ugly baby. So be careful about what you put on social media. Second thing I want to point out is that with your current employer, you probably signed a confidential information agreement and invention assignment. I'll talk more about this later. That agreement's going to have all sorts of clauses in there about what you can and about what belongs to the company. And it's going to have this carve out in a labor code. Importantly, even if it doesn't have this California carve out is going to apply if you're a California employee. California really does encourage mobility among employees. So you can count on these rules applying to you. But there's going to be a lot of other things in there. There might be non-solicitation clauses. There might be no hire, no poach. There might even be attempted non-competes. That stuff is really hard to enforce in California, not so hard to enforce in other states. So this is very state specific as to what restrictions an employee has when they leave one company and go on to another. Really important to check that document. In fact, in California, it's arguable whether somebody can even enforce a non-solicit against a leaving employee. You know what I mean by non-solicit? And been there many times on both sides. It means that the employer says, you employee, after you leave, you promise you're not going to call all your buddies back, all the other employees that I have and say, hey, come work for my new company. They're great. They have free lunch. We all go for drinks on Friday. You should work here. You're going to promise not to solicit. In California, it's arguable whether you can even do that. There's a case out there that says that an employer can't enforce that, but there are some. That was a recruiting company, so I don't know how much broad application it has, and nobody else does too. But we're very careful about that. Non-competes don't work at all in this state. You can't get an employee to agree not to compete with an employer when they leave in this state, in California, except in connection with the sale of the goodwill of a business. And sometimes we can figure out a way to do that. So and no hires. That's something that won't work. That would be an unfair trade practice here in California. So you can see it's a pretty restrictive state. You're pretty free to do what you want as long as you know the rules and comply with them. Now, let's suppose I'm just going to take this one more step since I'm started down this path. Let's suppose you and your founders, you started your company, or maybe you're hiring somebody who's coming from another company even. And it is a little bit close to what your prior employer did, but you listened to this course and you studied the slides and you were very careful about scripting how you did it, so you feel pretty confident. But your prior employer, they don't know that, so they're going to assume the worst. And as soon as you post on LinkedIn what you've been doing with your new company, you get a demand letter, and it says, "We want to remind you that we own certain IP." And if you steal that IP, if you use it, we're going to enforce our rights very vigorously. Remember that confidential information agreement and invention assignment that you signed. So don't freak out when you get that. A lot of companies, they just send that as a matter of course. They just blanket, for a better word, lack of a better word, but you do have to respond. And one really super good response to that in your new company is that, don't worry, we've made sure that your prior employee, who is now our current employee, did not take any of your IP. We made sure we did our diligence. Not only that, we even made them sign a representation where they promise that they're not taking anything from the prior employer. So there's ways that you can protect yourself and build a really good record in this case. All right. So that is our number 10, use of a prior employer's facilities. Lack of documentation. This is a big issue. In my first book, that if you listened to any of my talks before, you would have gotten a free copy of, called Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. I listed this as probably the number one problem for startups. The number one dead on arrival issue is just lack of documentation. And what I meant by that is there are some really big issues that just absolutely positively have to be put in writing. Equity ownership, right? Because if you can't agree on that up front, you might not be able to agree to it down the road after it turns out that you can be successful. And that's something you want to get in writing up front. And it's surprising how little writing it takes to satisfy this requirement. Just something in writing. Now, as a lawyer, I'd like to have a very robust stock purchase agreement and a cap table and lots of documents that go along with it. But just have something, because if it turns out the company's successful and now you've got a financier lined up ready to put money into it, you don't want to have an equity squabble among the founders. That'll chase your investor away in a hurry. Let me make sure my chat is open. Okay. So that's number one, but I want to go on a little further beyond that, because that's not the only issue. It's not the only thing you should have documented. Let me give you another one. Vesting, right? Vesting has to be in writing. Vesting has to be in agreement. You can't just go to your co-founders and say, well, everybody vests, so you should just assume that you're vested, even though you haven't agreed to it because we never got around to signing it. That doesn't work. It has to be agreed to. And trust me, the founder who's now departed, by the time you get to the financier, he's got a lot of leverage. If you haven't gotten him to agree to vesting, and now your new financier says he's got too much stock, we need some back, or we need him to agree to vesting now. So get all that stuff in writing up front. Here's some less obvious ones. This comes up enough that I call it out specifically. That's contributions by the founders. Here's a scenario. You started your company, you've used a little founder money. If you've come to our webinar, Funding 101, you would have seen some statistics and data on how much money founders actually put into their own companies. But you've probably put some money into it, and now it needs a little bit more money, and you're the founder, so you pump a little bit more money into it. What are you getting in return for that? Is that just what you're doing because you own stock? Are you getting additional shares? Are you getting a note? Does the company owe you that money back? Is that note or that debt that it owes to you convertible into stock in the next round? All that has to be in writing. All that has to be in writing. I've had one case in the last 5 years or so where this was a dead on arrival issue, because we had two founders. Imagine a scenario. You guys have probably all been there. One was viewed as the money partner, money bags founder. The other one was the brains, the service partner. He's going to do all the work. They had roughly equal stock ownership, we'll say. And the money partner just kept putting money in, just kept writing checks. Finally, we got to a point where we had a product. We had some traction in the market. We were ready to go talk to the institutional investors. And all of a sudden, this issue comes up, the stock ownership. And at that point, of course, the founder was putting the money in. He said, I should have more stock for all this money I put in. And I should at least get my money back because I loaned that to the company when we do the financing. And then, of course, the service partner said, well, no, wait a minute. That's not the deal. You're the money partner. I'm the service partner. That's your contribution. I put in sweat equity. You put in cash. Nothing's in writing. And that company failed because of that issue. It wasn't in writing. They couldn't agree. And the investors said, as they almost always will, you guys figure it out. I want no part of your litigation, no part of your lawsuit. So just be careful about that. A couple of other points I want to give you some takeaways. Unsigned agreements are not agreements, okay? Unsigned documents are not agreements. I get that all the time. Here's all our unsigned stuff. This is what we must have agreed to because somebody wrote it in a piece of paper. It's not signed, it's not an agreement. However, reliance can be an agreement. You know what reliance is? That's when you have that unsigned document that everybody treats as though it has been signed. By the way, if you're analyzing these sorts of issues, if you're thinking about these really interesting legal theories, it's too late. You've done something wrong. You should never even get there. But again, it doesn't take very much. Even a napkin can be an agreement. I've had many times in my career where people come to me with, I'm not kidding you, napkins from a bar with notes on it. this is what was promised to me. Here it is. And we've had to honor that. Okay. What's next? Excuse me. Lack of vesting restrictions. Let's talk a little bit about vesting. So does everybody know what vesting means? I know I mentioned it in the last slide, so let me expound on that. So vesting is the idea that people will earn into their shares over time. Excuse me, a little bit of a, hope it's just a cough. Anyway, people will earn into their shares over time. And the way it usually works is through a mechanism, a repurchase obligation at cost. So the scenario is the founder gets their shares, they pay almost nothing, a penny a share for their stock. And that stock, say it vests over 3 years. That means if they leave after the first year, they give back 2/3 of their shares. They actually sell it back at a penny a share, which is almost nothing. And they get to keep the 1/3 that they're vesting in. That's vesting. Typical founder vesting is around 3 years. Sometimes you see 4, every once in a while 5. I start with 3 and let the investors force us into 4. By the way, you will almost always be required to unvest and start over with your vesting schedule before your company gets sold. So keep that in mind before you fight too hard over 3 or 4 years, because when the investors come in, they almost always will restart you because they need to know you're going to stick around long enough to get that company to an exit. Secondly, there are things called triggers, and these are acceleration events. And this is the concept that if something happens, from the founder standpoint, you're thinking, gee, if something happens, something good happens to this company, sale of the company, I should fully vest. I've done my job. That's a single trigger. You fully vest me if this company gets sold before my vesting schedule expires. That's a single trigger. Another type of single trigger is if you fire me for no reason, no fault of my own, I should get vested because that's not my fault. You should give me my share. It's not like I quit, in which case it's fair for you to take my stock back. That's another single trigger. We don't see those very often anymore. What you do see, though, is double triggers for high-level people, founder-level people, not the rank and file. And that would be, a double trigger would be, look, if I get terminated without cause, and that's closely related to a sale of the company, then I should get vested because that's not my fault and I did my job. And we see that oftentimes. It's always negotiated, but oftentimes requested. All right, let's see. How long, who vests, cliffs, time-based. Sometimes we put milestone vesting. In other words, it's not just 3 or 4 years. You have to hit certain milestones. Rarely do I see that for founders. You'll see that for advisors. Now, advisors are different. Advisors are definitely not going to stick around after a sale. So we almost always give them accelerated vesting on change of control, right? Secondly, you shouldn't need them for that long a period of time. So we usually have a short vesting schedule for them, like 2 years. That's typical advisor vesting. And then milestones, as I said, it's not just time. The advisor is being hired to do, you know what an advisor is, by the way? They're not a consultant, they're not an employee, they're not a founder. You're hiring them for a very specific task or area of expertise. Maybe you're a fintech company and you need someone to advise you on how banks work. I don't know, maybe you need someone to get you into the market. Excuse me. So those are advisors, and typically it's a 2-year stint, and we'll give them milestones so that they vest when they actually get you those customers or do what it is that you've hired them to do. So on the tax side, this is a little tricky, and this is why you shouldn't try this yourself, really. But I won't go into all the technical details. Just suffice it to say that you have a very adverse tax result if you're granted shares, unvested shares, unless you make this certain election with the IRS, and you do it within 30 days of the transfer. It's critical, it's important. You can't be a day late or it's ineffective. And that's what they call the 83B election. If you don't make that election, you're going to have income inclusions over the term of the vesting schedule, likely. So make sure those get made. Now, here's a practice pointer for you. It is you, the shareholder, the employee, the service provider's responsibility to make that election. You can't count on a company to do that for you. Most companies will disclaim that obligation. Even if they do it, they'll say, look, you have to, this is all you. So be very careful about that. It could be a very bad result. Secondly, sometimes what we see, like oftentimes, like almost always, is vesting will be imposed on a financing. So the investor comes along and they say, look, we need, you've got unvested shares, but we want to impose this vesting. And the question comes up, do I need to make an 83B election in that case? The answer under revenue rulings is no, because there's no transfer going on. But be careful, because it does have to be imposed if vesting is imposed in connection with an M&A. So if you get new shares in a company, because you've sold your company, you've traded your shares for new shares, and those new shares are unvested, then you do have to make the election. It's all very arcane and technical and counterintuitive. So, and I can tell you, all the different ways this comes up. All I want you to know is that this is a technical legal tax requirement that you have to pay attention to, and you're better off having somebody else do it. Now, before we're at 12:30, so we got time, I want to move on to the story of Zipcar. It's the story I tell in the other talk that we do, Funding 101. This is a company that did not impose, they had a 50-50 owned company, and it did not impose vesting restrictions. And one founder did all the work, and the other founder got married, moved to Hawaii, had children, and did not do very much work at all. This is all public. You can go Google it. You can read all about it. So I'm not saying anything that's not public, and they're not my clients, just so you know. And they complained about that for years. Eventually, they got it worked out. Eventually, they ended up probably where they should be. 10 years later, after multiple rounds of financing and new investors coming in and imposing vesting restrictions, but it created a lot of stress on that company in the early years. And things would have been a lot more smoother sailing, according to the founder who did all the work, if they'd only gotten this part right at the start. So it's because it was Zipcar, they managed to survive this issue. A lot of companies wouldn't survive it. They would fold and fail and have to start over. Okay, next, top 10 legal mistakes is inadequate tax preparation. So there's very little tax planning, it seems, goes into startup formation. Very little. And I am primarily a tax lawyer, so I like to give this a little more thought than most. And the reason very little thought goes into it is because the default is almost always a C corporation formed in Delaware, because that's what the VCs insist on. And if that's your path, then this is a short conversation, and that's what you're going to do. You're going to do a Delaware C corporation, despite the fact that that C corporation is a separate taxable entity, has to pay tax on its income, and then when it distributes its earnings to you as a dividend, you have to pay tax again on those same earnings. Despite that, that's what the VCs want. That's what you're going to do. It's what every public company is a Delaware C corp almost. Well, they're a C corp, most of them, almost all of them, and most of them are Delaware. However, if you're not a venture capital candidate, and because people always ask me, well, how do I know if I should be a C corp, an S corp, or an LLC? And I say, well, if you're a venture capital candidate, be a C corp. Just might as well start as that, because that's what you're going to end up as. If you're not a venture capital candidate, if you don't need venture capital to succeed, if instead you're what I call a lifestyle business, where you're just going to generate some income, and you're not going to be hugely scalable, you're a yogurt shop is the example I usually use, because I've actually represented yogurt shops. They're very profitable businesses back in the early days anyway. But if you're a lifestyle business that's just going to generate some income and you're never going to go get venture capital, then you want to think about a pass-through entity. And by pass-through, what I mean is an entity that only pays one level of tax on its earnings. In fact, it doesn't pay any tax. The owners of the entity pay the tax on its earnings. And that's less than 2 levels, so it's cheaper tax-wise. Now, if you are thinking about a pass-through, that's 2 kinds. It's S Corp or LLC. It's not very often I see S Corps anymore. I used to see them constantly, all the time. There are circumstances when they work. I'll talk about it in a minute. But usually, if people are going to be a pass-through, they go all the way and they're just an LLC. It's just purely pass-through. It's as if I'm doing business myself. Who cares? The VCs are never going to invest in me. And S Corp is a pass-through that you can play games with self-employment tax, however. And what I mean by that is with an S Corp, the owner could lower their self-employment and Social Security tax burden by making distributions. And that's the game everybody plays with lifestyle businesses. Joe Biden has famously played that game himself with his own company. He has an S Corp. It has the royalties from his book, which apparently was more successful than mine, which is hard to believe, but it must have been because he had to form a corporation to recognize all that income. And he put it in an S Corp so he could avoid paying tax on self-employment income and Social Security taxes. Ironically, President Obama tried to eliminate that particular loophole in the tax code, but was unsuccessful. So I'm not saying there's anything wrong with it. Everybody does it. That is just bread and butter tax planning. That's the only reason you would use an S Corp, however, because everything else you give up. So number one, an S Corp cannot issue qualified small business stock. What's that? That stock issued by a C Corp has less than 50 million in assets. It's held for more than 5 years. And if you, the owner, sell it, you don't pay any tax on the gain for federal purposes up to $10 million. It's a huge benefit, a huge benefit, a humongous benefit. There's talk about making it go away for people who make over $400,000 a year in the Biden Build Back Better bill. But for now, it's a huge benefit. And even at that level, it's going to be a benefit for people who make less than that. So that's one you hate to give up. You know, no tax on the gain from the sale of stock. That's QSBS. It's a big one. So what happens if you're a company that you don't know if you're going to be the yogurt stand that's just going to make a good living for me, or maybe you're going to be the Biden book publishing company that's going to generate, quite a bit of money, but I don't want to pay higher tax than I have to on it. Or if I do get investors, I could scale this thing and we could knock it out of the park. And it could be huge. What if you don't know which one you are? In that case, I usually go with an LLC. And the reason why is because it's relatively easy to flip that into a C Corp. Not everybody agrees with me on that, by the way, because there are complications, but well planned and well scripted and well advised and well orchestrated, you can flip that into a C Corp when and if you get a VC. So you get the tax benefits at the front end of a lifestyle business and the benefit at the back end when the investors come in. So that's how I would do that. One last thing I'll say about this. If you have foreign founders, because about 25% of our audience is non-US, you're kind of stuck with the C Corp. You can't be an S Corp. And for tax reasons, you wouldn't want to be an LLC. It's a punitive tax rate for a foreign person who owns an interest in an LLC that operates a business here. So just keep that in mind. So C Corp is usually the answer, but give it a little thought depending on who you are. All right, we probably devoted too much time to that topic. Let's move on. Labor laws. Okay, awesome. This is the one place that startups almost 100% of the time are going to get wrong if you're in California and possibly if you're in any other states. But California especially, it's rare to find a company in California that can comply with our Byzantine set of wage and hour laws. And it's gotten worse. And let me give you, first of all, let me tell you, where do we start? Let me give you a little history. We've always had a big issue in this state with, and not the state, this whole country, with classifying people as employees or independent contractors. If they're employees, the cost of the business to hire that person is higher. It's about 30% higher by some studies, because you got to pay payroll taxes, benefits, insurance, workers' comp, all this stuff, vacation time, disability. So there's a lot more costs to that. So companies, of course, want to classify their people as contractors, not employees. So they don't have that burden. And of course, the employee contractor, they're okay with that because no one's withholding taxes from their paychecks. So it looks like they're getting more money. Plus, they're not getting benefits. Well, California hates that, right? And California has a law that is unique, at least almost unique. There might be one or two other states that have followed suit. That makes it very difficult to classify a worker as a contractor and not an employee. In fact, the presumption in California is that it's an employee unless you prove otherwise. And to prove otherwise, we now have this 3-part ABC test that says that it's actually aimed at rideshare drivers. And the test basically says that somebody's not a contractor unless not only are they free from your direction and control, but the service they're providing you is not your core business. It's not related to your trade or business that you're offering to the public. So as an example, this law was designed really to get at Uber drivers, to get at rideshare. So think about it, the platform, they hire a driver to pick me up and take me around. So Uber is providing me with the service and they're just subcontracting to this driver, this person to do it, automatically an employee. Now they've been carved out of the statute because of our proposition. Most of you are here in California, so you know this. So they've been carved out. Uber drivers, Lyft drivers, rideshare, they've been carved out of this law, but the law still exists for everybody else. And it's a very difficult law. It's forced a lot of people out of the state because if you're if you're in Tahoe City and you're an independent contractor and you're doing coding or something for somebody, and somebody in another state hires you, now all of a sudden they got an employee in California. On the other hand, if you move across the border to Incline Village and you do the exact same thing and get hired by the exact same party, you're not an employee, and they don't have an employee in any state, and they have a lot lower cost. That's forced a lot of companies out. A lot of people out. It's been a gig economy proposal that has forced a lot of gig workers out of the state. I'll just tell you that right now. Now, unfortunately, that's the good news. The bad news is that this law is kind of gaining some steam and other states are picking up on it and they're liking the idea. And our current federal government loves the idea. And there's a proposal to make this the law of the land as a federal law matter. In other words, the federal government would come and tell the states who it is that are employees or contractors in their states. And the policy behind that is that there's a perception that it's too easy to be a gig worker and they're being denied benefits and protections of employees. So some governments want to expand the protection. For you as a startup, what that means is that you have huge, massive exposure on this issue. Because if somebody is misclassified, you've called them a contractor instead of an employee when they really are an employee, you owe back taxes. You owe, you might have messed up your benefit plans. You've got work problems under your workers' compensation. And by the way, there are criminal penalties for not getting workers' compensation right. Plus, you owe back wages. You owe waiting time, you owe meal time, you owe vacation time, you owe overtime. You got all that stuff. And waiting time penalties, plus you have to pay their attorney's fees. It's huge. Not only that, it gets worse, at least here in California. Any employee can sue on behalf of all similarly situated employees under our Private Attorney General Act. So if you think I'm kidding, and if you think I'm being an alarmist, I will tell you, I've counseled many companies that this is the issue that put them under, right? And in fact, if you'd like to see a good example, Google HomeJoy. That's a company that was a platform. Think of it as Uber for housekeepers, where you could go on the platform and you could find somebody to come over to your house, clean your house. You pay the platform pays a housekeeper. You all go on your way until they had a class action lawsuit. They raised $40 million of venture capital, and that one lawsuit ended the company. That was it. They couldn't. The CEO said if it hadn't been for the lawsuit, it was because of the lawsuit they couldn't do a Series B round. So this is a serious issue. In fact, in my book that I'm going to send a copy to you, I have a whole chapter about it. And the chapter is about putting out fires. Because as a startup entrepreneur, you have to let a lot of fires burn. There are a lot of little things, a lot of issues where you're not 100% legally correct. I'm practical. I know that, even though I'm a lawyer and I'm not going to tell you to violate the law. I know there's a lot of things that you're not 100% correct, but we'll fix it later. Okay, we'll deal with it. PayPal is a perfect example of a company that ignored all the small issues until they had enough money so they could build a company. This is not a small issue. This is not a small fire. This is what we in California would call the Dixie Fire. All right. For those of you who are not in California, the Dixie Fire was the largest forest fire in the state's history. So this is a big one. This will take your company down. You really need to pay attention to this one. All right, moving right along. Failing to protect IP. This is another big issue, and it's an easy one to deal with. So if you're a typical tech company, like I'm used to working with, technology is super important to your company. It's one of your most valuable assets, and it's really important that you can claim ownership to it. So let me talk a little bit about protecting IP. Let me kind of go top down and give you some additional insights that I hadn't mentioned before. So you all know what a patent is. I think you do. That's a federal registration that gives you, the owner, the right to practice that particular trade secret for a period of time exclusively. So you can exclude others from practicing that particular invention, meaning using it. That's a patent. Patents are really good. You should have a good patent strategy. What do I mean by that? What I mean is that you want to patent the things that people are likely to reverse engineer, because that's how you're going to protect it. On the other hand, there's this other asset called trade secrets, which is probably your most valuable asset. And trade secret is not patentable. Trade secret is basically a secret that's valuable because it's secret, because it's got value to you, and because you've kept it secret and you've taken reasonable efforts to keep it secret. That's the third prong. Now, a good patent strategy is going to say, look, we don't really need to patent trade secrets that nobody can reverse engineer and figure out, because once we patent it, then the world can see it. And you'll say, well, yes, but you got legal protection because they can't legally violate it. That's true, but they will, okay? They will. You have to assume that, especially if they're a big, large, well-funded organization. And what are you going to do as a startup? You going to go sue them? Probably not. You'll probably just have to suck it up. So don't patent, stuff that people aren't going to be able to figure out anyway. On the other hand, you should patent stuff that they can reverse engineer, because they're going to have that information anyway. That's kind of a really simplistic way of saying it, but that is sort of the basic idea. That's a basic idea behind the patent strategy. Now, how do we get there? So trade secrets we talked about. The third prong, you got to take steps to keep it secret. That means NDAs, non-disclosure agreements with people that see the trade secret. That means having it locked out. It means being very secure. It means not talking about it on a public Zoom call. All right. There's recent cases now in the last year where companies have lost their trade secret protection by talking about it in a Zoom call that anybody could join. So that's a pretty important aspect of this. And then finally, that proprietary information agreement and invention assignment that I told you about earlier, this is where that becomes really important, because that's the document that your employees and consultants are going to sign. And it's going to say, look, even though I created this, I'm created it for you, the employer, and I hereby assign all my rights to you. If you don't have that from everybody who touched your technology, they might have some rights in it. They might have a non-exclusive license to use that particular technology. And if they do, what does that mean? It means that you, the company, cannot claim ownership, because ownership is the right to exclude others from using the IP. So be very careful about getting those in place. And by the way, a little more thought should go into the drafting of them, because you see these invention assignments very broadly drafted. And they always have an attachment that says, however, we're not assigning, the employee or consultant is not assigning all the stuff listed on attachment to this assignment. And that's fine, but a lot of times people don't even fill that out. And I worry about that because if you, the employee, don't fill it out, well, then you just assigned everything you have that's related to this business. And you might not have intended to do that. If you, the employer, don't insist that they fill it out, this is California. I can see a judge saying, look, you people didn't take that document seriously. You didn't even read it, right? You didn't even fill it out. You didn't even complete it. It's incomplete. I'm throwing it out. That could happen. So, put a little thought into these documents. Okay, we talked a little bit about trade secret. Let's talk a little bit more about it. Again, defined broadly as anything secret, formula, program, device, method, technique. It has independent value. And again, reasonable efforts to maintain its secrecy. So, again, this might be your most valuable asset. That's why I pause on this one. Your second most valuable asset is very likely your trademark, and you might not even realize that. And trademark is either the name or the mark that really distinguishes your company. So here's my process for trademarks. So number one, before you even adopt a name or a mark, do your research. And you can start with a Google search, right? That Kamala Harris just last week said, you want to find a testing facility, go Google it. Same with a trademark. You want to find out if someone's using your name, go Google it. But that's not where you should end. You should then do a Patent and Trademark Office search. And with a PTO search, PTO's Patent and Trademark Office, they do what they call a knockout search. You can search with the PTO as to whether somebody's using your name or mark. And then at some point, you may want to just actually file a federal registration so you've got protection. Now, you don't have to. The thing, unlike patents, the thing about trademarks and copyrights is that you get protection from actually using. With trademark, you get protection from using it in commerce, okay? But you don't know whether you got protection or whether you're infringing until you actually get a federal registration. And as has happened many times, I've seen happen, you could go along forever using your name and mark without a registration, and then you get to an event, a financing, an exit, a sale, something like that, and all of a sudden you get a demand letter because somebody else has your mark and they've been using it. And now you're done. Your company, you got to change your name, or what are you going to do? Or you got to license it. You got to pay them a license fee or something. And that often happens on the eve of a financing or a closing or something like that, when the party, we call it sandbagging. They have the rights, they sit on them, they wait until they have maximum leverage. They have maximum leverage when you absolutely have to be squeaky clean. So don't let that happen to you. Take care of it. The other thing I want you to think about is that depending on your company, your mark is so wound up in the value. Think about Snapchat as an example. I mean, Snapchat, I don't think the technology is all that difficult compared to other things, but the brand name, holy cow, that brand name is powerful. Can you imagine what would happen if somebody came along and said, Snapchat, you got to change your name and can't use that anymore? It'd be a pretty big hit to their market value. You can think of a lot of companies like that. You might be one of them. So your goodwill is wrapped up in your name. And goodwill is usually the largest asset that my companies have when it comes time to sell. So that's what I mean by branding your company. All right, I got a couple more things, and we've got 8 minutes left. I don't want to get too super technical. I do want you to know that the Internal Revenue Code doesn't make anything easy, including anything that looks compensatory. It looks like it's compensation. And 409A comes up in two places. Number one, when you do stock options. So the first issue is you've got a company, you've got a lot of stock, you don't have a lot of cash, you want to give stock to your service providers. There's some securities laws issues with that that we'll get to. So you give them stock options, but you don't have a stock option plan. So you adopt a stock option plan. And the tax rule now, as a practical matter, is that you need to have a valuation of that stock in order to grant the option. That's a safe harbor under Section 409A. If you don't have that valuation, you might be wrong on the value, because options have to be granted at fair value. For those of you who don't know, a stock option is a right to buy stock at a certain value. So if you have an option, a 10-cent option on a share of stock, that means you can buy that stock share for 10 cents a share. If the stock goes up to $1, you still get to buy it for 10 cents. That's the beauty of the option. You, the employee, you don't have to spend any money today. You just sit there with your option and wait for the stock to go up. and eventually you cash out the difference. The value goes down below 10 cents, you don't do anything. You don't exercise the option, you're not out of cash. That's optionality. You get the upside, but not the downside. The tax law wants to punish that in a way by ensuring that that option is granted at fair market value. Now, if it's not, then you have a non-qualified deferred compensation plan that does not comply with 409A. I mean, there are ways to make option plans do that, but it's incredibly complex. So just you would have an option grant that's invalid, meaning that neither has to be canceled if you catch it in time, which is not a fun thing to tell employees. And I've been there a couple of times. Or the employee has a big penalty, It's they pay the tax, plus they pay 20%, plus they pay interest, plus they do it again for state tax purposes in California. So it's a big number. You can't justify it, cannot be justified. You can't say we're going to plan into this. We're going to plan into not being compliant with 409A. The numbers will never work out in a million years. You got to comply or you got to be exempt. With a stock option plan, to be exempt, you get a professional valuation before you grant the option. There are other safe harbors that sometimes people try to shoehorn into. I wouldn't do it if I were you. The stakes are just too large. Just spend the money, get the 409A. The second place this becomes a problem is deferred salary. A lot of times what we'll say is, look, I'm a startup founder. I'm not going to take any salary until we sell the company or until we get a financing. That's possible, but that is a 409A plan. And you have to comply with the rules, meaning you have to have a written plan. It has to be payable on a certain event, et cetera, et cetera. So we can make that work, but it's it doesn't happen automatically. All right, let's keep going here. Failing to comply with the securities laws. I told you we were going to get there. Where to start? So first of all, it is super easy these days for you to get in so much trouble without knowing it, because you can go online, you can download a safe. And by the way, don't ever do that, because whatever document you download, you don't know what's in it. And if you're downloading a safe from, well, there are some safes, they call them post-money safes. You're not helping your company, you're helping your investor. So I wouldn't try to do it yourself. But you can, and that's a problem, because people will go online, they'll download documents, they'll fill them out, they'll take money, they'll give them a piece of paper. I've never met a non-lawyer who is able to do a blue sky filing. It's a very difficult process. It's a tough process. And blue sky means state securities laws. The federal is tough enough, but at least we have broad exemptions and they're relatively forgiving. States sometimes are absolutely not. And you may have to give the money back depending on what state it is. So those are the blue sky filings I'm talking about. A good reason not to do it. Form B is the federal filing. It's required. A lot of people skip it. I'm not going to tell you to skip it, but let's just say that a lot of people do. Now, the reason I'm telling you all this is not because I'm so concerned that you have to give the money back to the investor. I totally am about that. But what I really worry about is criminal liability. Now, you've all been watching the Theranos trial, which just ended. So if you don't think people can go to jail for securities violations, just Google Theranos. And I'm not saying that what you're going to do, rises to the level of what was alleged in that case, because that was securities fraud. I am saying that I know lots of people who have, not lots of people, I know two people, in fact, who have gone to jail for securities law violations for not doing anything fraudulent. They just screwed it up. They just messed up. In one case, the guy couldn't count very well, and he was like Bugsy, the casino in Las Vegas. He sold it 2 times over. This particular founder sold his company more than 1 time. He just screwed up. He just was bad at math. I really don't think he intended to do that. Judge didn't see it that way. He went to jail. All right. He didn't have a lawyer help him with that, so no one was keeping track. Another case, the founder was selling stock to people that had no business buying stock. They weren't sophisticated at all, and they didn't understand what they were getting into. And the founder didn't tell them, and was wildly optimistic about what he was going to do with this technology. And it turned out none of it worked. He raised a lot of money and then went to jail. So I'm just telling you, this is serious stuff, and I just wouldn't do it myself. And I know there are even lawyers out there that will say, hey, just go online and download a safe and use that. I'm telling you, just don't mess around with Big John Law. All right, crowdfunding, I'm not going to talk too much about that other than to say I think it's a great option for a lot of companies. I didn't say that 10 years ago when we first got a crowdfunding statute, but it has evolved and it has gotten a lot better since then. Okay, I'm going to move a little more quickly since we're getting towards the end. And this is my last actual substantive bullet point for you, is I really want to make sure that you as a founder live to fight another day and that you do not assume personal liability. It is just a fact that most startups fail. It is just a fact. It is a brute fact, okay? That doesn't mean that every startup you form is going to fail. In fact, even the huge successes, if you talk to founders with huge successes, I always like listening to their biography. The honest ones will say, well, these two succeeded and these three failed. You know, it's just going to happen. When that happens, you want to be able to go out and start another company and live to fight another day, as I say. In order to do that, it's important that you don't have personal liability for that company, right? When it fails, it's the investor's risk capital that is at risk, and maybe whatever money you put in, not your house, not your 401k, you know, not your wages. You don't want to get garnished, none of that stuff. And I have some fairly extensive commentary on this on my YouTube website, which you should totally go to and subscribe to if you want to hear more about how to stay out of trouble. And I think everybody ought to. But let me give you the top ones for now. So number one is taxes. And what I mean by that is by payroll taxes. That is the number one place where founders, and not only founders, anybody who has any authority to direct a payment can get in trouble if for not paying the IRS the employee share of payroll taxes. So that's automatic personal liability. Got to make sure the taxes get paid. And when you are in that company that doesn't have enough money to pay everybody, you might think about paying the stuff you're personally liable for first. Wages, we now have a law in California that will hold the promoters of a company personally liable for not paying wages. We've always had it. It's just become a lot more teeth in it lately. And in fact, those cases are starting now where employees are suing owners of companies because the company didn't pay wages. By the way, on this, we also have a criminal statute fairly recently called theft of wages. So an employer can be criminally responsible for not paying wages. And it gets better. We also now, if to form a new company in California, you actually have to certify to the Secretary of State that you haven't been guilty or been found to be guilty of non-payment of wages. So this is pretty serious stuff. Make sure that stuff gets paid. Fraud, again, go look at the Theranos trial. It's a real good roadmap of what not to do, what not to tell your investors. And by the way, let's pause on that. The thing that's interesting about that trial is that when there's two different kinds of fraud, there's common law fraud, which is a really high bar. You have to be a very bad actor. You have to have very bad intent. You have to intend to deceive somebody. They have to actually rely on the fraudulent thing that you told them. I don't know if they would have gotten there at Theranos under that standard. Then there's securities fraud, which is a much lower standard. And you can get in trouble under either statute, and you can be criminally liable under either statute. So keep that in mind. And then finally, contract. Just don't go contracting for liability. You know what I mean? That means guaranteeing the lease, guaranteeing the line of credit, guaranteeing a credit card. You've probably already done it. But if you can avoid a guarantee, I've got plenty of stories in my new book about how to do that. That'll help you out. I'm going to add one more here. It's not on the list because this is a very recent case, just came out of Delaware, which is supposed to be such a company-friendly place, but they just expanded their law now to hold directors liable. It's a bankruptcy case for self-dealing in a case because they didn't feel like the transaction was fair enough to the corporation or that they disclosed it and got consent. So be super careful about self-dealing. The screws are tightening on that. Finally, my last point is make sure you get a lawyer that understands startups. Not all lawyers are startup experts. You might be the best bond lawyer in New York City doing multi-billion-dollar bond offerings, exactly the wrong kind of lawyer for this kind of deal. Similarly, you might do, something else, personal injury, that's wrong for this. Make sure you got the right lawyer. And the good thing is here where I practice in Silicon Valley, Palo Alto, there's plenty and plenty of good lawyers, not just here, but in other places in the country that have big startup communities. So there are plenty of lawyers that know this stuff. I just hate, seeing companies that just don't know what questions to ask because they were not represented. All right, that's me. My information is in the chat. Feel free to email me if you have any questions. Use the Q&A if you've got questions you'd like to answer right now. This is my old book. You can find it online, and I will be sending you my new one after we're done here. Now I'm going to stop the share. Okay. All right, let's go to the Q&A. All right, Q&A. Where's my Q&A? Here we go. First of all, let me double check the chat to see if anybody, because I see a lot of questions in the chat. Why don't you go ahead and pop those into the Q&A and we'll take them in order. Oh, here's a good chat question. Post to chat for the prior recordings. I think I did that, but I'm going to do that again because I want to make sure everybody has that. All right. Okay. Let's go up to the top here. Question number 1. When you trademark a word as someone who's already using it in a different field, somebody's using it for diapers and you want to use it for cigars. Yes and no. And let me tell you why I say that. Because the idea behind trademark is that we want to protect the company from confusingly similar names. I'll give you an example. I used to work for a law firm 20 years ago. And it had the words general counsel in its name. And one day I got an email from a lawyer in New York City going on and on about some case that the claim, about my supposed client. And I could not figure out what the heck this was all about. And it took me forever. And I finally figured out that it was another law firm that had the name words general counsel in their name. That's confusingly similar, right? So somebody there, was probably violating someone else's trademark. So part of it is that if you're in the same field and if the name is confusing and similar, that's a trademark violation. But there are other types of claims, or call them dilution claims. Like I don't think I could call my, you could call yourself the Rolls Royce cigar company, even though Rolls Royce does not sell cigars. That dilutes their brand. So the answer is yes and no. Let me just put it that way. Okay, question about trade secret. Trade secret is just know-how formula that you want to keep secret, right? It could be. So if someone developed it himself and patented it, you just lose it. Isn't that right? Yes, that is right. That is the problem of trade secret. That's why I say you trade secret to stuff that can't be reverse engineered. Is there any way to protect it as a patent? Yes, that's why I say patent it. If it can be reverse engineered, then you patent it. Then you got the protection, and then they can't use it. And our system here is first to file, keep in mind. So that's the moral of the story. And that's why I say strategy. That's why I say it's a patent and trade secret strategy. They ought to work together. Okay, what's the difference between a stock option and vesting? Okay, so as you know, stock is ownership in the company. A stock option is a right to buy that unit of ownership in the company, a share of stock. Either a stock option or a stock can vest. They can both vest. Now, when we say stock vest, that means that the stock is subject to a right of repurchase when somebody leaves. They just lose the unvested shares. When we say that an option vests, is a little complicated. What we really mean is that the underlying stock is vesting, so that when you exercise the option, you either exercise just for the vested shares, or you exercise for all the shares, but some of those shares are unvested and can be repurchased. Now, sometimes people, they talk about vesting and exercisability the same, although they're not. So there's another concept here called exercisability. And oftentimes, in fact, most of the time, we'll tie vesting to exercisability, meaning that we'll say you can exercise your option for the vested portion, right? So if I'm 50% vested, that means I can exercise and buy 50% of the shares, and all those shares will be 100% vested. Some option plans allow you to exercise for all of the shares, vested or not. So if I'm 50% vested, I exercise for 100 shares, 50 shares are vested, 50 are unvested. So that's the concept. Okay. I'm one of two founders, the CTO, the other founder is the money guy, or an LLC. Potential issues with your LLC. Boy, that is a broad-based questionnaire if I heard one. So here's the thing about LLCs is that they're super, like, in a way, they're simple and easy. They're a pass-through, but they can be super complex because the way they differ, LLCs differ from corporations in one really fundamental way, other than tax. Corporations, pretty much everything is set by statute. Got to have a board, got to have officers, got to have shareholders. You know, it's all statute. It tells you what you got to have and what they're going to do and what their roles and responsibilities are and duties. LLC isn't like that. LLC, you got to have a member, right? But you only need one. I do think you need a member, especially in Delaware. But that's about it, right? And your operating agreement is going to define everything else. Do you want managers? You know, otherwise the member's the manager. Do you want officers? You don't have to have them. You can have them. Do you want directors? So that part has to be set forth in your agreement. You have to agree on all this stuff. The corporation's code will just supply all that for you. You give them the names and the roles, and they'll tell you what that means. They'll tell you what a president does. LLC, you need an agreement to tell you that. More importantly, you need that agreement to tell you the economic rights of the parties. What are people putting into the company? What are they getting back? How is income being allocated for tax purposes, etc.? This is all part of an agreement. So that's what you really have to watch out for. And with LLCs, where it's most easy to get this wrong, is to mess up on the tax distribution idea. Because people sometimes confuse the idea of income and cash flow. They're completely different. Income, especially taxable income, is just an accounting construct. It means how much income you're going to pick up on your income tax return and pay tax on. Doesn't mean how much cash you got out of the company. So we have to be super careful in the agreement to specify what happens with income, who pays tax on it, and where the cash goes. So I like to think of it as money in, money out, okay? You just got to get that all nailed down. So you have to be careful. So LLCs are really a lot more work, I think. You can have a lot of benefit from it, but they are a lot more work because you have to think through all those issues. And we haven't even gotten to the management issues. Who's going to be the manager? Who's going to vote? How many votes? You know, what information rights do you have? What reporting do you have? What happens when you liquidate? What if you go bankrupt? All this stuff. So there's a lot to think through. There's a lot to think through. And again, I just don't advise people to try this themselves. I probably drafted 1,000 LLC agreements, okay? I know this area pretty well, and it took me about 500 of them to get it right. So just keep that in mind. How is AB 25, is it 2557 different than AB 5? Isn't it 2257? Well, I know what you mean. So AB 5, AB 5 is, okay, little history lesson here. So first of all, we had this case in California called Dynamics that basically, that was the anti-Uber driver case, the one that said, well, California adopts this ABC test so that if the service you're performing is in the line of business of the service recipient, then you're their employee automatically. Okay, that was codified by statute in AB 5. We all expected the legislature to do something about that bad case. They did do something about that bad case. They made it the law. They turned it into a statute. The governor signed it. So now it's the law in California. And the law basically treats a lot more people as employees that used to be independent contractors. They don't want to be employees. Nobody wants them to be employees, except the state of California. So they are. That's just the way it is. Then AB 27 came along, 2557 came along and said, well, look, us lawyers are a very powerful lobby. So we lawyers think you legislatures should carve us out from that statute. And the legislature said, well, gee, you guys do make a lot of campaign contributions, so you're accepted from this rule. Everybody else, they have to suffer through it. Well, then we had several other groups come up. You wouldn't believe it. You wouldn't believe the exceptions. They make no sense at all. The only thing I can tie it to is how strong the lobby is. For example, psychologists and psychiatrists are treated differently. One has a stronger lobby than the other. I'm not making this up. We now have more than 60 exceptions to AB 5, 60 different categories, on top of the fact that the voters in California have carved out rideshare drivers. So Uber, Lyft, DoorDash, they're not subject to this law either. And those exceptions keep growing more and more. We just got a new one this year for newspaper distributors. Go figure. Why are newspaper distributors different than anybody else? Well, if you read the statute, and I have, it says, well, it's First Amendment and the right to news is really important and blah, blah, blah. Yeah, baloney. They're a big lobby. We all know it. That's the California experience. And pardon me for getting a little excited here, but it's just, it's ridiculous. But what you need to know is two things. Number one, you got to pay attention, because as ridiculous as these laws are, they are the law and they will bite you, and they have teeth. They have really big, sharp teeth, right? They're the big bad wolf of California law. So the second thing you need to know is that there is a movement afoot to make it the law of the land in all of the United States, without the exceptions. Without the exceptions. I left that part out. So watch out. All right, where are we here? Okay, somebody wants to negotiate a non-recourse profit share arrangement to fund my project. Will an investor still require vesting? I think what you're saying is that you're doing like a seal or a shared appreciation loan or royalty financing. The idea is you sell a stream of income to the investor rather than equity in the company. Will the investor still require vesting? I have done those deals and we have not required vesting. However, now that I think about it, I don't know why not, because you got to have that person stick around long enough to make the company successful to generate the profit share. So I think they will if they think about it, but my experience has been is that they haven't in the few that I've done. If a founder is operating without any legal agreement, can they be held accountable by a third party? No equity, no partnership, no salary. Yeah, you absolutely can. What you are then is a sole proprietor. And a sole proprietor has no protection at all. Let's take a big step back for a second. That question scares me. Take a big step back. Kind of the biggest reason I'm here, probably the biggest reason that I have a job is to protect people from liability. And the way we protect them is by forming entities. Limited liability companies, corporations, sometimes limited partnerships. If you don't have that entity conducting your business, then you are the business and you are personally liable for all the debts and obligations of that entity. And we never do that. You never want to do that, right? You always want to have that entity. And that entity is very powerful. Now, it's not perfect. You've all heard about cases where for fraud or excess or whatever, those veils get pierced. I have a whole chapter on that in my book that you're going to get. I'm going to tell you how to avoid that from happening. Let me pause on that for a minute here. In fact, it happened just this week. I was on the phone with another lawyer and like, well, we don't know about these entities. If something goes wrong, someone's just gonna pierce the veil. Okay, you hear that all the time. Pierce the veil means they disregard the entity and they hold you, the owner, personally responsible. And yes, that can happen and does happen. Doesn't have to happen. It's wholly avoidable. It is wholly avoidable. If you do things correctly, instead of on do-it-yourself legal sites, you will not have that problem. If you mess up, you absolutely will have that problem, and all of your entities will have been there for nothing. Now, here's the example I like to use. How big a risk is this? If you're doing it yourself, it's a huge risk. Just read the cases. Read the cases. They're all out there. If you do it through a lawyer, doesn't have to be me, but through a lawyer, here's where I think your risk is. I think it's small. My book is called 10,000 Startups because that's probably how many that I've counseled. And in all that time, I will tell you, most of them have failed. That's just startup land. Most of them do not succeed. And of them, and by most, I mean a large percentage. In fact, I did go back and look up a lot of them lately. And anything I formed 20 years ago, 1 in 1,000 is still around. And of the ones that fail, most of them are going to leave creditors holding the bag. Probably most of them. And of those creditors holding the bag, a lot of them are going to be so unhappy about it, they're going to go ahead and do whatever they can to enforce their liability, and they're going to sue. So in all of those 10,000 cases, how many times do you think that one of my companies has had its veil pierced? 0. Never, never. I can count on one hand. I've actually had to face the claim, and 0 times it ever prevailed. So if you do things right, you don't have to worry about liability. But if you don't do anything, you are on the point of the spear for sure. Let's see here. I want to put forward, oh, somebody says, what's the term for a group of companies that will work with you for some ownership? I'm not sure I know what you mean. You might be referring to accelerators or incubators. They take an ownership stake in order to provide you, or venture studios. Sometimes they'll even give you money to provide you with services, support, and also additional funding. Someone wants to put forth an intellectual strategy. I think you mean an intellectual property strategy. Can that be a trade secret? Yeah, as we discussed, trade secret will absolutely be a part of that, but you should also have federal registrations, patent and trademark protection. How to protect trade secrets from employees and contractors. Since you're you say DNC holds no weight. I'm not sure what that means. I think you might be talking about the NDA. Yeah, that is an absolutely great question. And here's how you should think about it. When your employees walk out the door, your trade secrets walk out the door with them. Sorry to say, legally, it's not supposed to work that way, but all the paper in the world just doesn't protect you from that. So what can protect you from that? Well, what can protect you from that is having a really good trade secret strategy that, number one, keeps these trade secrets secure and doesn't allow any single employee to see the whole picture. Here's a good question. Why does anyone invest in a startup if most of them fail? Because the ones that don't fail, it's high risk, high reward. The ones that don't fail do spectacularly well. It's kind of funny you should say that. I was just going through trimming my list this weekend of stuff I've invested in and who's hot and who's not. And I got to say, the ones that didn't do well, they're 0. They're just 0. The ones that do well, they're not here. They're like up there in the stratosphere. That's just startup land. That's why. All right, getting back to your question, the NDA is not just enough. So what you really need to do, think about, we all hear the story about Coca-Cola, how nobody can see the whole formula. I don't really believe that story, to tell you the truth. I think Coca-Cola is probably pretty easy to replicate. In fact, I think everybody has done it already. There's plenty of colas that taste like Coca-Cola, but I like the idea. You don't let any one person see the formula, right? Because you don't want to let that one person walk out the door and replicate it. And that's what good trade secret strategy is. You wall people off from various aspects of what you're doing. So you reduce that risk. Having said that, there are pieces of your IP that are going to migrate, and you'll do the best you can to enforce your rights, to have good agreements, and send those nasty letters that I was talking about when employees do leave, reminding them that they have these rights. And if it gets to be too egregious, just go Google the Lewandowski Waymore, what's that company? Google case, and you'll see what happens when somebody does take trade secrets. Steal trade secrets, or is alleged to steal trade secrets, and someone else gets really pissed about it. In that particular case, the offender not only ended up with hundreds of millions of dollars of liability, but also went to jail. Let's see, trade secrets. Does it even make sense to keep a trade secret? Anyone can patent it, and you lose everything. Well, this is always the debate, and some lawyers will say patent everything, patent often. I have partners that say that, patent often, and everything, because that's your only protection. And then some people say keep it secret because once you patent it, it's out there. So I think it's going to have to be it's going to have to be one of those fact-specific discussions that you have. Just make sure you work with a lawyer that kind of understands your strategy and what you're doing. How hard is it to convert from LLC to C Corp? Is it a hassle for a brand new startup? Is it better to close and open a new C Corp? It's better to convert if your LLC actually has something. If it has an asset like intellectual property, a name, customer contracts, employees, relationships, etc., it's super easy to convert. So how hard is it to convert? As a corporate law matter, it is super easy. We file a one-page conversion and poof, you're converted. As a tax matter, it can be very complicated. So you have to be careful about that. Involve your CPA. You might trigger an income inclusion on conversion. We don't have time. I'd walk you through how that happens and how to get out of it. But it is an issue to think about at the tax side. The other thing to think about is on a conversion, and this is one of those things that fall. And by the way, I do a lot of these, and I just noticed there's a million things that can go wrong and that can fall through the cracks. And one of the things that often does is you got to get the stock issued to your former LLC members. Now I have to have shares of stock, and you want those shares of stock to have all of the rights, preferences, and restrictions of typical stock in a C Corp. So we got to get all the right documents in place. So even as a corporate law matter, you could file a one-page document. You wouldn't want to do it that way. So sorry, that's a long answer. The answer is could be super simple, but you want it to be a little bit more thoughtful than that. Let's see. Is this all likely to happen in European countries or no? Which one is most common in Europe? Yes, it absolutely. Now, this is all US law, but these concepts are really pretty much global to a greater or lesser extent. For example, IP ownership. When we do IP, because my clients are all international, so when we do an IP agreement and we have a contractor in Turkey or someplace, we need to have an agreement that complies with the law of where the company is, usually California, and the law of where the individual is, the service provider, Turkey. So these concepts do apply. One concept that applies everywhere in every market is this lack of documentation. People just seem to not do that, and it's really important to do. By the way, I just saw that movie House of Gucci this weekend. I don't know if you've seen it, but there's a scene in there where the old man dies and the lawyer says, well, we got a problem. If only he had signed a certificate, you wouldn't be bankrupted by taxes. But because he forgot to sign before he died, you owe billions and billions of lira in taxes. Okay, that's Italy. That could be. I've done business in Italy. I've seen stuff like that happen there, but it's not quite that bad here in the US, but it is the importance of documentation. I'm not going to tell you how they survived that problem. You're going to have to go see House of Gucci yourself, but I thought that was pretty interesting. There was also a big IP lawsuit in the middle of the movie too, that I thought was kind of funny. Okay, is there a startup friendly package for initial due diligence? Email me. I'll tell you about it. Did additional categories get added to AB 2557, not exemptions, but other people that have to be included? No, because AB 5 is very inclusive, and an AB 2527 just carves them out, if you know what I mean. All right, so in your agreement, the founders signed an agreement that they will not dispose of any shares for 3 years. Okay, let me tell you, here in the US, you might have enforceability problems with that. In other words, we have this rule against restraints on alienation. In other words, if I own something, the nature of my right to ownership of this thing is that I can transfer it if I want. I can give it away. I can sell it. That's just part of ownership. So for me to enter into an agreement that says I agree not to sell this, well, that's inconsistent with the whole idea of ownership. And some courts will just throw out that agreement. So it's kind of risky to do that, to say we just agree not to transfer. Instead, what we would do is have a right of first refusal, because courts will enforce those. They'll say, what is this thing anyway? I don't know. Anyway, they'll say, look, if you want, before I can sell this little doll to you, I have to offer it back to this other guy and give him the right to buy it first. So that's important. So that's how we would restrict alienation typically, not really through just a blanket restraint. All right. Copyright as a method for protecting later patent claims. Yeah, that white paper for yourself only. That's way above my pay level. Although actually, on my website, I did have a guest author write about that topic, about copywriting your patents. So that is a thing, believe it or not. Okay, let me see if I got everything else here. You can try to use the Q&A if you have questions. How easy is it to enforce trade secret agreements and NDAs when you're in different jurisdictions? Let me give you another practical kind of just, you know, this is just paper, right? And these are legal rights. And if you're Google and Amazon, you've got armies of lawyers and you can get the attention of the courts and you can enforce your legal rights. So you rely pretty darn heavily on that paper, right? If you're a startup company or if you're in a country where paper just doesn't mean that much because people are going to ignore it, you rely a lot less on the paper. So I can draft all these agreements. Just keep in mind, you know, you still ought to be more careful about that because people will breach agreements. That is 40 years of law practice, and I can tell you, people will breach agreements. And not only that, they will lie about it. Not only that, they will lie under oath about it. Okay, so just use some common sense in this stuff. Use a good set of legal documents because you need that. But you also have to be a little careful too and understand, you know, what the world is really like out there. And if you don't understand, I advise you to watch House of Gucci because that will teach you a lot about what business is really like. Okay, and with that, we're at 1:30 p.m. I want to thank you all for being here. Again, you have my contact information. If there's any, I didn't get to all your questions, email me if you'd like to follow up. I'm happy to chat. Follow me on LinkedIn. Please subscribe to my YouTube channel so you can get all this awesome content. And we will see you next time.